Saan yung phone volume?
Good. Thank you. Hello, and thank you for joining me for this employment-based webinar by Ivylaw office. My name is Wilberforce Agyekum. I'm an immigration attorney here at the law firm. I wanted to do the webinar on this topic here to just to show you what kind of options are out there. Obviously, when it comes to immigration, most people think about, I'm still letting people in, so bear with me here. Most people think about family or humanitarian and those types of immigration, which is popular, which we do here at Ivylaw office. But we also, now we're picking up our practice in the area of employment-based visas, which are immigrant visas, and trying to assist those who want to at least get some more information on that option and would like to at least consider the option of petitioning based on employment or skills, extraordinary ability, scholarship, those type of people who are able to come to the United States and contribute right away to the country by way of as an employee. And then through that vehicle, you do get an opportunity to earn a green card and bring your family to the United States based on the employment and the skills that you bring. So this talk won't be too long. I'm just going to go over, briefly the 5 categories and then give you a brief description of what they are and some of the requirements. And after that, if you want to get more detailed information about these visas, and that if you are interested in yourself applying and you need assistance, we at Ivylaw office will be happy to assist you wherever you are, okay? So keep that in mind, okay? You don't necessarily have to be, obviously, if you are overseas and you want to come to the US based on work and employment or skills that you have, then this webinar should at least provide you some of that information that you need, okay? All right, so, all right, so let's jump into it. The employment-based visas. There are 5 employment-based visa green cards denoting preference that give an individual permanent residency in the United States. So the one from EB1 to 5, the numbers are the preference category, which they go in order from 1 to 5, and that's the preference because there's a certain amount of visas that are allocated each year. So they categorize based on preferences, skills level, all that type of stuff. So, and then, so the first one, EB1, is preference for green card with an exceptional ability, individuals with exceptional ability. And we'll go into that and what that means in just a couple of slides. And then there's EB2. The EB2 is a visa, and a green card eligible visa for individuals with advanced degree or exceptional ability. Okay, advanced degree or exceptional ability. Please mute your mic if you come on. We'll get into questions later. So the EB3, which is preference 3, is green card skilled professional or other workers. Skilled professional or other workers. The EB4 visa is for special immigrants, and we'll get into that. There's quite a few categories of those, so we'll get into what those are. And then the final one is EB5 visa, and that is for It's a category for investors. So that's preference 5. Okay, so let's get into EB1. The EB1. EB1, this preference is reserved for persons of extraordinary ability in the sciences, arts, education, business, or athletics, outstanding professors or researchers, and multinational executives and managers. Okay, let's go into the first one now. First category, which is really the big one. Persons with extraordinary ability. Persons with extraordinary ability. And the description here is that you must be able to demonstrate extraordinary ability in the sciences, arts, or athletics through sustained national or international acclaim. What does that mean? So this is what you must show. You must meet at least 3 of the 10 criteria below. We'll get to that, those 10 criteria in a minute. Or provide evidence of one-time achievement, such as a Pulitzer, an Oscar, Olympic medal, as well as evidence showing that you will be continuing to work in the area of your expertise. Okay? You will be continuing to work in that area once you come to the United States based on the EB1 visa. That you do not require an offer of employment or labor certification for this particular category claim, okay? You do not require an offer of employment or labor certification, okay? I'll explain why that is in a little bit. Okay, and then this EB1 category is for outstanding professors and researchers. Outstanding professors and researchers. What does that mean? You must demonstrate international recognition for your outstanding achievements in a particular field. You must have at least 3 years experience in teaching or research in that academic area. You must be entering the United States in order to pursue tenure or tenure track teaching or a comparable research position at a university, institution of higher education, or private employer, okay? And you'll be required, you must meet at least 2 of the 6 criteria listed below. We'll get to it after we look at the third one. And provide an offer of employment from the prospective U.S. employer. The private employer must show documented accomplishments and that it employs at least 3 full-time researchers. Also for this category, no labor certification is required. And then here, the third category for the EB1 is certain multinational manager or executive, managerial level or an executive level individual, okay? Now, what does this mean? It means you must have been employed outside the United States for at least 1 year in the 3 years preceding the petition or the most recent lawful non-immigrant admission if you are already working for the U.S. petitioning employer. The U.S. petitioning employer must have been doing business for at least 1 year, have a qualifying relationship to the entity you work for outside the U.S., and intend to employ you in a managerial or executive position, okay? Requirements to show your petitioning employer must be a U.S. employer and intend to employ you in a managerial or executive capacity. Again, the petitioning U.S. employer and must be intended. Hello? Okay. Your petitioning employer must be a U.S. employer and intend to employ you in a managerial or executive capacity. The petitioner must have been doing business in the U.S. for at least 1 year as a legal entity with a qualifying relationship to the entity that employed you abroad in a managerial or executive capacity. There's a connection that must be shown. Also, for this category, there is no labor certification required, okay? And we'll get to that labor certification stuff in a little bit too. Criteria. So these are the 10 criteria that we refer to. I'm going to go through them. So in order to demonstrate you have sustained national or international acclaim and that your achievements have been recognized in your field of expertise, you must either include evidence of a one-time achievement, which if it is one time has to be huge, major internationally recognized award, like an Oscar or something, or Nobel Prize, Pulitzer, as we referred to earlier, all 3 of the 10 listed criteria below. All comparable evidence if any of the criteria do not readily apply. So if none of these apply, then you have to get creative. But these are the criteria. Evidence of receipt of lesser nationally or internationally recognized prizes or awards for excellence. Evidence of your membership in associations in the field which demand outstanding achievement of their members. So associations which demand outstanding achievements of their members, you can show that as evidence if you belong to such an association. Evidence of your membership in association, just right there. Evidence of published material about you in professional or major trade publications or other major media. So anything, major publication that shows you, that highlights you, that spotlights you, that interviewed you, that, you know, that have you in it, and you can provide that proof, that would be evidence that could be considered. Evidence that you have been asked to judge the work of others, either individually or on a panel. You've been asked to be a judge, maybe a beauty contest, an award show or something to that effect, and you've been asked to be a judge. Evidence of your original scientific, now this is important, original is the key word, okay? Evidence of your original scientific, scholarly, artistic, athletic, or business-related contributions of major significance to the field, okay? Now, this can be, for the scholarly documentation, you can be a co-author, co-researcher, so it doesn't necessarily require that it was only you. You can be part of a committee or a group or a duo that drafted it or came up with it or invented it or what have you. But you have to show your contribution to it and that it was significant. Also, next is evidence of your authorship of scholarly articles in professional or major trade publications or other major media. Scholarly articles that you authored that is being respected and used by others in the trade or the profession, okay? Also, next is evidence that your work has been displayed at artistic exhibitions or showcases. So obviously, if you're an artist, a visual artist, and you can show that you have had exhibitions and displays and, you know, gallery openings, those type of things in major places and locations, that would be helpful. Evidence of your performance of a leading or critical role in distinguished organizations. So basically your critical role, not just a role, leading or critical role in a distinguished organizations, okay? It doesn't have to be one, it can be multiple, all right? Now, evidence that you command a high salary or other significantly higher remuneration in relation to others in the field. So here they want you to demonstrate that you have been paid well, highly paid, based on comparison to others in the same field that you're in. So obviously, this is where basically show me the money. If you make a lot of money doing that, obviously they're saying somebody is paying you a lot of money because you have exceptional abilities in that particular field or area. That can be one form of showing that you are as a person of extraordinary ability, that you make a lot of money, okay? Also, finally, evidence of your commercial success in the performing arts. So if you are a performing artist, musician, or actor, or anything like that in the performing arts space, a dancer, and you have evidence that you have been successful in that arena, you want to provide that information as part of your application. So it's not exhaustive. Not every one of these criteria will fit for everybody, but you need to come up with 2 or 3 in most of these criteria requirements to be able to apply and qualify for the EB1. Okay, all right. So, I think. Hold on a second. All right. Okay, so examples of documentary evidence that a person is an outstanding professor or researcher. Outstanding professor or researcher, okay? In order to demonstrate that you are an outstanding professor or researcher, you must include evidence of 2 of the 6 listed criteria below, or comparable evidence if any of the criteria do not readily apply. Again, we're still talking about EB1. Evidence of receipt of major prizes or awards for outstanding achievement. Evidence of membership in associations that require their members to demonstrate outstanding achievement. Evidence of published material, professional, written by others about the non-citizens' work in the academic field. Evidence of participation, either on a panel or individually as a judge of work of others in the same or allied academic field. Evidence of original scientific or scholarly research contributions in the field. Evidence of authorship of scholarly books or articles in scholarly journals with international circulation in the field. That's what you would need to come up with some of these criteria to show that the documentary evidence to show that this person is an outstanding professor or researcher. Okay. Finally, on the EB1 application process, for the extraordinary ability, you may apply for yourself by filing a Form I-140, petition for alien worker. For the outstanding professor and researchers, your U.S. employer must file a Form I-140, petition for alien workers, as part of the application process. Your employer must be able to demonstrate a continuing ability to pay the offered wage as of the priority date. Your employer may use an annual report, federal income tax return, or audited financial statement to demonstrate a continuing ability to pay your wage. For the multinational manager or executive criteria category, your U.S. employer must file USCIS Form I-140 petition for alien worker as part of the application process. Your employer must be able to demonstrate a continuing ability to pay the offered wage as of the priority date. Your employer may use an annual report, federal income tax return, or audited financial statement to demonstrate continuing ability to pay your wage. So those, the two categories, outstanding professor and researcher, multinational manager or executive, require a lot more demonstration of ability by the employer, whereas the extraordinary ability, basically, you can petition and file your own by yourself based on ability to prove with evidence that you are indeed a person with extraordinary abilities. Now, for EB-1 visa holders with respect to family, if your I-140 petition is approved, your spouse and unmarried children under the age of 21 may be eligible to apply for admission to the United States in E-14 or E-15 migrant status respectfully. So your family will be able to join you once your visa is approved. Now for the EB-2, advanced degree or exceptional ability. EB-2, preference 2. This preference is reserved for persons who are members of the professions holding advanced degrees, or for persons with exceptional ability in the art, science, or business. For the advanced degree, you must have an advanced degree or its equivalent, which is a bachelor's degree plus 5 years of progressive work experience in the field. For the exceptional ability, you must be able to show exceptional ability in the sciences, arts, or business, which will greatly benefit the U.S. economy, cultural, or educational interests, or welfare in the future. Exceptional ability means a degree of expertise significantly above that ordinarily encountered in the sciences, arts, or business. Keywords, significantly above that ordinarily encountered. So you are extraordinary. You're not an ordinary scientist or a member of the arts community or a member of the business community, but you are significantly above the average, okay? So you have to be able to demonstrate that for the EB-2. The national interest waiver. If you are requesting that the USCIS waive the labor certification for this EB-2 category, because it is in the national interest of the United States, you are eligible to file a petition on your own behalf, if you believe doing so would be in the best interest of the United States. You may do this whether you seek to classify yourself as a member of a profession who has an advanced degree, or if you have an exceptional ability, okay? And second. Okay, let's move on. For EB-3, the EB-3 is for skilled, professional, or other workers. Skilled, professional, or other workers. This preference is reserved, again, now, some, not everything fits neatly into a particular bucket. So you may have to reach out to an attorney to figure out where you fit in, okay? Some of it's pretty self-explanatory, but your particular situation might not be so straightforward. So talking to an attorney can help you at least, guide you to where you need to go in terms of your application and which visa may be best for you. Okay, so here, the skilled worker. The skilled worker is a person whose jobs require a minimum of 2 years training or experience, not of a temporary or seasonal nature. The skilled worker must meet the educational, training, or experience requirements of the job opportunity. Relevant post-secondary education may be considered as training, okay? So if you have a relevant to the job of a post-secondary education, that may be considered as training. For the professional criteria here under EB3, those are persons whose job requires at least a U.S. baccalaureate or foreign equivalent degree and are a member of the profession. At least a baccalaureate or a foreign equivalent degree and are a member of the profession. So those professionals, be it doctor or lawyers or other such professionals, you want to reach out also to a U.S. lawyer, immigration lawyer, to make sure you fit in this category. Other workers, namely unskilled, subcategory for persons performing unskilled labor requiring less than 2 years training or experience. It requires less than 2 years training or experience. Skilled worker requires a minimum of 2 years. So that's the major difference between the two, the skilled and unskilled, not of a temporary or seasonal nature, okay? All right. Okay, EB3 continued. The application process for the EB3. Your employer, who will be your petitioner, must file a form I-140, immigrant petition for alien workers. As part of the application process, your employer must be able to demonstrate a continuing ability to pay the offered wage as of the priority date. Your employer may use an annual report, federal income tax, or audited financial statement to demonstrate a continuing ability to pay your wage again. For your family, if your I-140 petition is approved, your spouse and unmarried children under the age of 21 may be eligible to apply for admission to the United States in E34, spouse of a skilled worker or professional, or EW4, spouse of an other worker, or E35, child of a skilled worker or professional, or an EW5, child of an other worker. Okay. Again, please, at the end, you'll get my contact if you want to have a specific conversation about your situation. I'd be more than happy to start that conversation with you, okay? All right. For the EB4 preference four of employment-based visa. You may be eligible for an employment-based fourth preference visa if you are a special immigrant. Among these, we find the following: religious worker visa, special immigrant juveniles, broadcasters, G4 International Organization or NATO 6 employees and their families, international employees of the U.S. government abroad, armed forces members, employees of the Panama Canal Zone, certain physicians, Afghan and Iraqi translators, Afghan and Iraqi citizens who have provided faith services in support of U.S. operations. To petition for an employment-based fourth preference immigrant, your employer must file a Form I-360 petition for an Eurasian widower or special immigrant. However, there are certain situations where you, the employee, may self-petition on your own behalf. Reach out to us at Ivylaw office and we can go over those options with you if you are interested in the self-petition under EB-4. And with respect to families, some EB-4 classifications allow your spouse and unmarried children under the age of 21 to be admitted to the United States. So keep in mind that is the consistency of it. You can't, not everybody, every member of your family are classified as admissible to the United States based on the approval of your EB visa. But generally, spouses and children under 21 are admissible based on the approval of your visa, okay? So keep that in mind. Now, again, not all children, your children who are under the age of 21, okay? For immigration purposes, 21 is the cutoff for minor, okay? So that, keep that in mind, not all your children, just those under 21. Okay. Now, EB-5. EB-5 visa, it's a green card for investors. Investors, those who have money and wish to invest in the United States. You will be granted a an immigrant visa, and which you obviously qualifies you for a green card and eventually citizenship, but this is the process. Under EB-5 program, investors and their spouses and unmarried children under 21 are eligible to apply for a green card if they make the necessary investment in a commercial enterprise in the United States and plan to create or preserve 10 permanent full-time jobs for qualified U.S. workers. Again, those two are together. It's not one or the other. So keep that in mind. It's and, okay? Commercial enterprise in the United States, you're going to invest, and then you plan to create 10 permanent, not part-time, not contract, not seasonal, 10 permanent full-time jobs for qualified U.S. workers. Okay, so this must be done under the EB-5 investor program. So it's the fifth category preference. Now, briefly about that program, Congress created the EB-5 program in 1990 to stimulate the U.S. economy through job creation and capital investment by foreign investors. In 1992, Congress created the Immigrant Investor Program, also known as the Regional Center Program, which sets aside EB-5 visas for participants who invest in commercial enterprises associated with regional centers approved by the USCIS based on proposals for promoting economic growth. So all that says is you have to find the regions that need particular types of commercial activity or investments and get it approved by the regional center program. And then you can go ahead and be on your way to submit these documentations to that particular program. Okay? Again, if you have questions, if you want to get more clarification on any of these, you're going to have to contact us at the office and we'll be happy to talk about it with you. Additional information on the EB-5. All EB-5 investors must invest in a new commercial enterprise that was established after November 29th, 1990, or on or before November 29, 1990, that was purchased and the existing business is restructured or reorganized in such a way that a new commercial enterprise results, or expanded through the investment, resulting in at least 40% increase in the net worth or number of employees. So it's either a new one or one that is being basically restructured, reorganized, revitalized, and there has to be a 40% increase in net worth or number of employees based on the part that you're going to play. Commercial enterprise means any for-profit activity formed for the ongoing conduct of lawful business, including a sole proprietorship, a partnership, whether limited or general, a holding company, a joint venture, a corporation, business trust, or other entity which may be publicly or privately owned. Now, this definition includes a commercial enterprise consisting of a holding company and its wholly owned subsidiaries. If each such subsidiary is engaged in a for-profit activity formed for the ongoing conduct of a lawful business. I know I don't have to emphasize lawful, but yes, your business cannot be unlawful. Your investment, your venture that you're investing in cannot be unlawful. It has to be a lawful business. I know it should go without saying, but some people may be out there listening thinking, no, lawful. Now, the definition does not include non-commercial activity, such as owning and operating a personal residence. If you're doing rentals for your home, whatever you're operating there, no, it has to be commercial, it has to be out there, it has to be job creating, it has to be one of these areas that we discussed just now, okay? All right. Summary. So approximately 140,000 immigrant visas are available each fiscal year for non-citizens and their spouses and children who seek to immigrate based on their job skills. If you have the right combination of skills, education, and or work experience, and are otherwise eligible, you may be able to live permanently in the United States. The 5 employment-based immigrant visas preferences provide you opportunity to do just that. The goal is to find out which one you should go with. And that is where lawyers can assist you with that and also qualifying you. So your best bet is to reach out, okay? Now for the bonus, those of you who were able to join me today, the golden coupon code. If you call the office or come in the office or schedule any type of appointment to talk about these or any other immigration issues at our office, you will get from July 1 to August 31st. So time is short. You want to use this soon and come in.
Ms. Tolson.
It's a complimentary 10 minutes free call with the attorney if you want to talk quickly by phone to see if we can help you out or at least let you know what we can do to help you. All $20 consultation fees for 30-minute immigration consultations, all 10% off. And you will also get 10% off your legal fees for retaining our services. You can call and schedule an appointment at 301-276-0887, or you can find our contact information at our law firm's website, ivylawoffice.com. Okay, so we have reached the end of the webinar. I want to thank you for joining me. Some of you are still here, and I'm going to stop the screen share and see if anybody has anything want to say or you want to ask. Again, not going to be able to answer or analyze or provide specific advice or anything like that on this webinar, but I will be happy to talk to you if you are able to come into the office or schedule a meeting by Zoom, or you can schedule a call back by phone if that is your preference. If you are overseas, we prefer you call in to us, or you send us an email, or schedule a virtual meeting, and we'll be happy to accommodate. Okay. Those of you in the Maryland area, you have the option to come and talk to us at the office. I am happy to meet with you at the office if you are interested in having more information about the EB5 or EB1, EB2, EB3, EB4. But if you are definitely, obviously, most of these will be individuals who are overseas and may be interested in coming to the US based on one of these employment-based categories. And reach out to us and we will be able to assist you regardless of what country you are in. We are happy to talk to you and assist you, okay? All right, so that is it for today. I am going to stop the screen share. All right. How's everybody doing? You can unmute your mic if anybody wants to say something. Okay, so as I indicated, you can visit us at the law office by phone, by website. You can also reach us through our Facebook page or our Instagram page. We also have a channel on Facebook, the Ivylaw Office TV. Okay, Ivylaw Office TV. You can reach us there too. We have a weekly Q&A on Facebook, on YouTube at 2 o'clock during the weekday on Wednesdays. So please join us sometime for that. We have an estate planning webinar seminar coming up live in person at the end of July. You can also look on those platforms for information on that estate planning seminar, which will be presented by Jumoke Oladapo. Okay. All right. So thank everybody for joining me. And I'm going to, hold on. Oh, thank you. I appreciate it. I'm glad it was informative. And again, if any of you want to have a follow-up, please contact us and we'll be happy to schedule you to come in. Okay. Thank you very much, everyone, for joining us. Share the information. We will repost this webinar on our Facebook and our YouTube page, so you'll be able to share and have other people also get that information as well. Thank you, everybody. Bye-bye. Be safe.